Hello, everyone. I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for another 30-minute skills. For those joining us for the first time, welcome. These monthly lessons are a quick and efficient way to hone your reporting skills and build on your First Amendment knowledge. But as many of you already know, they're also more than that. They're a way for you to reconnect with a community of journalists, researchers, attorneys, and academics who regularly attend these lessons. So, to everyone, please use the chat to introduce yourself, showcase your work, connect with others. And also, make sure you register for our upcoming lessons. Registration links can be found at nefac.org. As a reminder, previous 30-minute skills are available at nefac.org and on our YouTube channel, 5 Freedoms. Lessons include data cleaning, privacy law, Microsoft Excel basics, and how to diversify sources, among many other topics. Today's presentation is the first of 2 classes on copyright law, and it's supported in part by the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. We have a lot to cover and not a lot of time, so let's get started. Rob, all yours.
Good afternoon, everybody. My name is Rob Bertsche. I'm a media and First Amendment law partner at a boutique law firm called Klaris Law in Boston and New York. And we're going to be taking off a lot to chew today. We've got 2 sessions, as Justin mentioned. The first one, Copyright Law 101, will be dealing with the purposes of copyright, what it protects, what exclusive rights a copyright holder has, how long copyright lasts, how you register your copyright, and some of the scary penalties for copyright infringement. Copyright Law 102, which we'll be offering in a month or so, excuse me, we'll be dealing with how you can use the work of others, both by permission, by license, but also the very interesting and complex subject of fair use. So let's get right to it. One fun thing about teaching copyright law is that everybody knows something about it, and most people know something wrong about it. But it's something that grows out of the U.S. Constitution, not the First Amendment, which many of us deal with in parts of our practice, but Article 1, Section 8, that says that Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what the Copyright Clause is doing is it's saying, look, we're going to give the creator a monopoly on the use of their work and the sale of their work, among other things, because as it's been said by Samuel Johnson, nobody but a fool ever wrote except for money. You may take exception with that fact, with that saying. So that's the one part, is to give the copyright holder, the person who creates, an incentive and reward for creating. But it's also to provide the world with the benefits of that creation. And that's why that monopoly is provided for only a limited period of time. I want to just briefly point out, because the concepts can get confused, the difference between copyright and trademark. Copyright is something that protects a creator's rights to their original creative works, their music, their movies, their articles. It's intended to incentivize that creation, as I've mentioned. Trademark is something different. It protects words and symbols that denote a particular brand. Coca-Cola is a trademark. The Nike swoosh is a trademark. I understand that Barbie has a trademark on its particular brand of pink. And trademark law is really designed to facilitate economic transactions so that you know the source of goods and services. So they're very, very different kinds of concepts. Today we're dealing with copyright, which protects the original expression of an idea that's fixed in a tangible medium. Now, you often see that little C with a circle around it on a book or something to indicate that there is copyright held. Contrary to public myth, that copyright symbol is not required. in order to have protection for copyright. Your work is protected by copyright the moment you write it down on the page, or you put it onto that recording, or fix it in any tangible medium, so long as it is an original expression. You're not required to register it in order to have the protection of copyright. You're not required to have that notice. Now, there are reasons why you might want to put that notice there. The obvious one being to let people know that, hey, I did this work, I have the copyright, you can't use it without getting my permission. And I'm the person to contact. So you put copyright Time Magazine, and they know to contact Copyright Time Magazine in order to get permission to reuse your work. But it's not necessary in order to have the legal protection. However, registration of copyright will be necessary before you can sue for infringement of that copyright. And timely registration of a copyright is a necessary prerequisite before you can get the really hammerhead penalties of what we call statutory damages, which I'll talk about in a little bit. And statutory damages are what make those cease and desist notices that you get in the mail saying you've inadvertently used somebody's copyrighted photograph. That's what makes them so scary, that statutory damages attach that have not necessarily any relationship to the actual injury suffered by the copyright holder. So copyright can protect, obviously, verbatim expression, word for word expression, but also close paraphrases. Copyright can protect the way you express and organize your composition, the story elements, the organization. It can't protect headlines or cover lines, but it can protect the name of a series or logos that are repeating. So if you have a newspaper with a repeating column, you might be able to trademark the name of the column, but you won't be able to trademark the headline on any particular article. It does not generally protect facts or ideas. And this is an important thing to remember. Copyright protects expression. It doesn't protect ideas. It doesn't protect contemporaneous speeches because they're not fixed in a tangible medium. And it doesn't protect works that are in the public domain, for example, because their copyright expired or because they've been committed to the public domain. I want to point out the difference between plagiarism and copyright infringement because they can get confused sometimes. Plagiarism happens when you present someone else's work as your own and you don't provide attribution. It's an ethical, journalistic violation. It isn't really a legal concept. It's a scholarly concept. It's a concept that may have great force and effect at your newsroom or place of employment. But attribution is not a solution to a copyright problem because copyright is copying the creative expression of another person without their permission. Even if you attribute it, even if you say, here, I'm giving you this poem and it's written by Rob Bertsche, and I'm going to sell it to you. You can't do that without Rob Bertsche's permission, even though you've attributed it to me. That's not plagiarism. You've given attribution, but it is copyright infringement. So how do you become the owner of a copyright? Obviously, the most obvious way is you are the creator of the work yourself. But there are other ways that it can come about as well. One is what they call a work for hire. You're an employee and you created the work in the course of your employment. Typically, I know many of you are journalists. That's what you do for a living. You write articles for your newspaper or for your website. And the work that you create, you do not own the copyright in it. Your employer owns the copyright in it, unless you have a contract with them that says otherwise. Another way you become a copyright owner is you commission a third party to create a work and you designate it as a work for hire in a freelance contract. So that's what happens when you send out a freelance contract. A magazine, for example, contracts with a freelancer. The freelancer is the original creator, but by virtue of signing that freelance agreement, the freelancer is assigning over to the magazine their rights, and the magazine becomes the copyright owner. A third party can assign the copyright in the work to you in writing, or can license certain rights of the copyright and the work to you. So who owns the copyright in this interesting picture? This is a picture of Neruda, who is a macaque, which I'm probably mispronouncing, ape in Indonesia, I believe. And this photo got taken because a particular photographer was traveling in Indonesia, in Sulawesi, Indonesia, and was taking pictures when suddenly Neruda reached out, grabbed the camera, and took a selfie. And I must say, he's an adorable little guy, if I do say so myself. Who owns the copyright in that? The photographer didn't actually click the button. He's not the one who took the picture. Neruda is the one who took the picture. So does Neruda own the copyright because he's the one who took the picture? He's the one who set it up. He's the one who designed it, who created that scenery, such as it is. Well, it became an issue when the photographer wanted to sell this photograph, and PETA, Society for the Protection, People for the Ethical Treatment of Animals, sued and said, no, photographer, you're not entitled to the profits off of the sale of that photo, because Neruda is entitled to it. And we're going to represent Neruda, and he should be getting the profits. And it actually went to court, where a judge, a district court, federal district court judge, ruled, in fact, that an animal cannot take a photograph taken by an animal is not, in fact, copyrightable. And the U.S. Copyright Office took it one step further. They came out with a special report that said the U.S. Copyright Office will register an original work of authorship, provided that the work was created by a human being. Unless there be any doubt about that, they continued, the office will not register works produced by nature, animals, or plants. And then they went even further, just so we wouldn't be confused. They gave a list of examples of the types of work that cannot be copyrighted. They said a photograph taken by a monkey cannot be copyrighted, nor can a mural painted by an elephant. I don't know if we've had one of those yet. Nor can a claim be based on driftwood that has been shaped and smoothed by the ocean. That sculpture of driftwood that has been shaped by the ocean is not a copyrightable work. And then even further, because the Copyright Office wants to close out any possible eventualities, they said, likewise, the office cannot register a work purportedly created by divine or supernatural beings, although the office may register a work where the application or the deposit copies state that the work was inspired by a divine spirit. Well, PETA and Slater, the photographer, finally entered into a settlement of his lawsuit, and they agreed that the case raises important issues, and they agreed that the profits from this photograph would be going towards a trust fund to help Neruda and his fellow macaques. What about artificial intelligence? Who owns the copyright when you use DALL-E or ChatGPT to create an image or to create a literary work. We say to DALL-E, create an oil pastel drawing of an annoyed cat in a spaceship. And we get this. Do I own the copyright because I told DALL-E what to do? Or does DALL-E own the copyright? Similarly, we could tell ChatGPT, why not? I'm busy today, so let's have ChatGPT do it. Write a cease and desist letter to a media company that has used a celebrity photographer's photo without permission. And you do that, and this is actually what I got. Dear media company, we're writing to you on behalf of celebrity photographer to demand that you immediately cease and desist. And I'd say this is as good as you're going to get from many, many lawyers. The Copyright Office has taken the position that artificial intelligence generated art cannot receive copyrights. And in a sort of related development, it's been found that artificial intelligence programs might infringe copyright themselves by generating outputs that resemble existing works. Because if you can show that the output from the artificial intelligence generator is based on having access to somebody's copyrighted work, and it comes out with a substantially similar output to the original work, then that might in fact be an act of infringement. Obviously, that is a hotly debated and rapidly changing part of the law that's worth following. What are the exclusive rights? What does being a copyright owner get you? Well, it gets you the right to reproduce the work, to make copies of it, to give it to other people, to put it on your website, whatever it may be. It gives you the right to prepare derivative works, a second work that's based on some preceding work, whether it's a translation or a movie version of a book or a fictionalized version of a true story or a reproduction of an original artwork. It allows you to distribute copies of the work or to perform the work publicly or display the work publicly. So let's do a thought experiment. Now, Starry Night by Vincent van Gogh, created in 1889, is not under copyright protection. But what if it were? What if it were still under copyright protection? Would somebody be able to create a derivative work based on it? Well, no. So what is that derivative work? Well, is that a derivative work that would be prohibited as an infringement of copyright? It's not the same, but it is a derivative work based on that original work. What about this one? I'm jumping ahead now, but some of you maybe start be thinking about fair use, which we'll talk about in a month. And maybe this is fair use for reasons we can talk about then. Same with this one. Now, I mentioned that copyright gives a protection for limited time periods to authors and inventors. The idea being, although you get a monopoly for the start, you can't have that monopoly forever. You only have that monopoly for a short period of time. That short period of time used to be 14 years with a 14-year renewal term. That's back in 1790. That's a reasonably short period of time. Today, it has gradually increased and increased and increased, and to the point where we are now at a place where individually held works have a copyright term of the life of the creator plus 70 years. And a work for hire, a corporate created work, has a term of 95 years from first publication. That created the problem of Steamboat Willie, created in 1928, and whether he would fall into the public domain in 2024. That says 2004, but I meant 2024. And that had Disney all in a tither. And so they passed what was called the Sonny Bono Copyright Term Extension Act, which some mockingly call the Mickey Mouse Copyright Extension Act. And they extended copyright term for 20 years, so that the duration of copyright now is at these much longer places. The question went to the Supreme Court about at what point does a very, very long monopoly term no longer constitute a limited term of copyright in accordance with the Constitution. And the Supreme Court essentially said, look, so long as it's a limited number of years, it's a limited term, which somewhat undermines the goals of the copyright clause. That's something you'll find generally with copyright law in general. It is riddled with contradictions, and it has not kept up well with technological advances. If you want to figure out whether a particular work is still in copyright term or under the public domain, I recommend you go to this site, which is what all the lawyers turn to as well, that takes you through the complicated calculation of what copyright term is and when it expires. Here are some of the works that joined the public domain in 2024. House at Pooh Corner, Sonny Boy, Lady Chatterley's Lover, Peter Pan, and yes, the original Mickey Mouse and Minnie Mouse from Steamboat Willie made their way this year, January 1, 2024, into the public domain. Now, how do you register your copyright? I don't have the time to tell you, and it's a lot of detail, so I want you to go to the U.S. Copyright Office website, and they have actually a really great series of resources there, both in terms of describing copyright and a level of detail that I haven't been able to here, and in terms of telling you how you can register different kinds of works with the Copyright Office. And what is at stake? Well, we'll talk about this a little bit more next time, but what's at stake is that if you infringe someone else's copyrighted work, you may be liable for handing over your profits that you got from the infringing work, reimbursing the copyright owner for the profits they lost, paying their attorney's fees, which may be the most onerous piece of all, or the copyright holder whose rights have been infringed can choose to receive statutory damages, which are damages that don't necessarily have any relationship whatsoever to the actual harm suffered. And they range from $750 to $30,000 per work infringed. I'm dealing now with a copyright claim that involves a calendar photo for a weekly newspaper that somebody picked up off the internet and popped into their calendar page 10 years ago. And because statute of limitations is tricky in copyright claims, and because of the statutory damages issue, the newspaper, if in fact it is found to have infringed, could be in court to the extent of $30,000, even though that bears no relationship to the probably $25 licensing fee of that particular work. And the people who are likely to sue: professional photographers, stock houses, but also people who, if you're a journalist, you wrote a story, they don't like your story, but you did it so well, you've learned so well through the libel 60-minute program that they don't have any viable libel claim, but they do have a copyright claim perhaps because you didn't pay as much attention there. So they'll bring a copyright claim because all they want to do is get back at you. So it's easy to bring copyright infringement claims. It's costly to defend them, and that's why it's important to know about all of this. And we'll continue this in a month. I'm open to questions.
Great. Thanks so much, Rob. Appreciate it. This is all great stuff and really helpful, particularly as we move forward and begin to identify creative works that might receive copyright attention. A couple questions before we wrap up here. I know we'll be touching upon it more in depth in our next class, but we have one person would like you to discuss just a bit or tease for us fair use and what is newsworthy related to copyright. So, for example, when someone can use a photograph on social media if it has news value, what something that might be newsworthy, for someone. They post it to Facebook, but they're not giving explicit permission. Any thoughts there about the news value that photo has and our rights to use it without permission?
Yeah, the fair use can be a very tricky subject. The fact that something is newsworthy by itself does not mean, and easy to cut and paste it from the internet, does not mean that it's fair use. It's got to be fair use is something where you're actually transforming the use. You're not reproducing the work for the purposes that it was created in the first place. You're using it for some different reason. So let's say there's a controversy about a photograph. You might be able to reprint that photograph because you're talking about the photo. But if you're talking about a plane that went on fire, and you have pictures from somebody on Facebook who was next door to the plane and took pictures of it going on fire, you don't have the right to use that their pictures without their permission. That would be a copyright violation, even though they're really important. There's no other way you can get them without getting them through them. It's very newsworthy. And that's what can make fair use enough of a topic that I've really saved it all for next month.
Right. So a good reminder to register for that class for next month. Make sure you're receiving updates about that lesson. A couple others, we just have a few minutes left. How about pictures and creative works from sites like Flickr and Pixels? Is it just the terms of service for those sites that we need to pay attention to, or are there other considerations we should keep in mind?
You really need to pay attention to the terms of work. There are certain sites that dedicate, then provide you with works that are committed to the public domain. And they're saying you can use this, or you can use it, you've got this under a Creative Commons license as well. They might say you can use it under certain conditions if you let other people use it and share alike and that sort of thing. And so that is a very good source. And we'll talk about that a little bit more next time too. But that is a very good source of public domain works.
And getting back to the area of ownership, if you could speak to works for hire or employee-employer relationships. So, for example, if you have a reporter that is using their own computer, phone, printer, all their own equipment, but then's laid off, all that unfinished work, that material that reporter collected and created on their own, who owns it? Who does it belong to?
The employer.
The employer in most cases, because they're an employee.
Yeah.
Working for the
because they did that work as part of their employment. Now, typically, you're going to work out something when something like that happens, because you need each other. The newspaper can't do anything with it without your help, and you can't do anything with it without having the rights to it.
All right, last question before we wrap up here. Now that we're getting better at identifying creative works and works that might receive copyright attention, any guidance for those situations where we can't easily figure out who the owner is? We have some material in front of us. We're trying to get permission. How do we figure out who owns the content to begin with?
It's a huge problem, and it's a bigger problem because the term of copyright has gotten so long. So there are a lot of what they call orphan works, works that are theoretically under copyright term, but nobody knows who, and nobody's making any use of them. Nobody knows who has the ownership of them. Use all the powers of the internet. Go to the Copyright Office, which has a catalog that is more accessible now than it ever has been in the past. And there are some special services that do these sorts of searches as well. But it's at the end of the day, your guess is as good as mine and how to go about doing that.
Thanks. And I should know another resource that might be helpful is we have a 30-minute skills lesson on verifying online sources. And in that lesson, there are some tools that might be helpful, like reverse image searches and so forth. So I
Yes.
encourage everybody to check that out. But we are out of time, unfortunately, but we're going to continue next month with Copyright Law 102. Rob, thank you so much for this lesson and being here today. And many thanks to everyone else for joining us too. We provide these lessons as a public service to all of you. So please return the favor and encourage your colleagues and friends to join us each month. We have a lot to learn from each other, and I look forward to seeing you all again soon. So on behalf of BFAC, thank you. Thank you so much for all that you do, and we'll see you next month for our next 30-minute skills. Bye, everyone.